Appeal Division 1 is now in session.
Thank you. You may be seated. So we are here today on our case number 1CA-SA150315, Garza versus Gama, real party and interest, Swift Transportation Company, Incorporated. Council, as you know, each side's allotted 20 minutes. That's what our order said. If we've listed a number of issues to cover. If it takes longer, then it will take longer. The petitioner may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of that time. The clock on the podium reflects the total amount that you have remaining, including what you may have decided to reserve. We record the proceedings, so please, when you approach the podium and for the petitioner each time, we appreciate it if you would identify yourself and the name of your client. We have read the papers you filed in your appendices, and we've looked at the Superior Court record to the extent that it's available to us. You know from looking at the order that we sent out a few days ago that we have several issues that we'd like you to cover, that we'd like you to address. We understand that as it has evolved now, the class action, the class alleges a two-pronged breach of the duty of good faith and fair dealing. One, as we understand it, is the fact that there's the allegation that Swift breached by selecting the software for use in calculating the mileage, and second, breached by failing to disclose to the drivers how that software worked and what its implications were. We may have that wrong, but that's what we discern from the filings. What we are particularly concerned about as we address the petition for special action is if that's the case, if those are the claims, then what are the damages that might be available to class members under each prong of that claim? How are they to be calculated? What do they consist of? And how the knowledge of any individual member of the class may bear on both elements of that two-pronged claim, or both of those claims for breach of the duty. So those, I think all those issues are summarized and recapitulated in a series of questions we posed, I think. Anyone else have anything to add before we begin? Okay.
No.
All right. With that long-winded explanation, you may proceed. Thank you.
Good afternoon. May it please the Court. Rob Carey on behalf of Leonel Garza, the petitioner. Your Honor, I would clarify one thing that you referenced where you said the two prongs of our claims. You said the selection of the Household Movers Guide. It's not the selection so much. They clearly could have selected. It's how they used it. So one is how they used it, and the other is what they explained to the drivers so the drivers understood what the pay scheme was. So based on the Court's questions in the briefing, I'd like to cover three things real quickly. To identify the substantive elements of the claim, the good faith fair dealing claim in Arizona, what the relevant proof would be under those elements, and what form the proof would take. Second, I'd like to, relying on those principles, go over the damages and the damage disclosures that we've made in this case, and one little complication that arose in the trial court that I'll explain, which it's not been briefed, it's not been raised in their motions, so the record's a little thin on the damages side, but I'll do the best I can. Third, how affirmative defenses are typically handled in class cases and how they should be handled in this case. So let me start first with the elements, because that will drive a lot of the questions the Court has. And it's important, we all know Arizona good faith fair dealing law. You have the cases cited in our briefs. We have Wells Fargo, we have Taylor, Those stand on the shoulders of Wagenseller and Rawlings. And they say, look, two things. One, you have to stay faithful to the common purpose of the contract. And two, you can't do something that's inconsistent with the justified expectations of the parties. Even if you do it without spite or ill will, it's a violation if you stray from those principles. But beyond that, if you go look at the cases that we've cited and the cases they rely on, Wagenseller and Rawlings, they say this: when you're trying to decide what the benefits of a contract are, the relevant inquiry will always focus on the contract. The benefits that we're talking about of what the justified expectations are in a good faith and fair dealing claim are derived from the language of the contract, the autonomous expression in the agreement. That's where it ends and starts. So if you don't have it in the agreement, if you can't figure out whether it's improper to do one act or another from the agreement, then you've got a problem. Because the corollary of that is also that the disclosures are affected here. The disclosures that the trial court said, look, they disclosed this and they disclosed that. It does not affect your contract rights. And again, these are contract rights. These are contract rights. And what you're doing is you're looking at the covenant and you're saying, based on the social policy of the state and the language of the contract, you can't do this certain act. That's what the essence of the contract is.
Counsel, you'll agree that the Superior Court has tossed your contract claim.
Well, true, but the good faith fair dealing still, my point is, it's still what you can or can't do under the good faith and fair dealing still arises from a contract.
Will you agree with me that you can have a good faith and fair dealing claim where you don't have an actual breach of the contract?
Yes, I would. But whether or not it's a breach of the contract, whether or not it's a breach of the covenant of good faith and fair dealing can only arise out of the language of the contract. You have to look and see in the contract whether something was contemplated or not. You could say, I'm looking at the plain language of the agreement, and even though the contract says this one thing, it's clear from the plain language that you can't go do this way. You can't use it this way because it violates the other concept of the language of the agreement. So when you read it in, I think it ends up in the same place. And Garza 1 basically acknowledged already that when you take a truck driver and you say, drive from Denver to Phoenix and go through I-25 to I-40 to I-17 and down in, but you calculate his pay off of a route that comes out of Denver and goes through the San Luis Valley and down through Santa Fe and across to Holbrook and down through Heber, and you calculate his pay off that route, that may be 700 miles, but the route you required the employee driver to drive and you recommended that the O&O drive has to go down. They have to go down on the interstate system and go down. That may be 750 miles. So what Swift's doing, just to be clear, is they're sending out a route, and it says take the interstate system the whole way. But they're sending a mileage figure that's calculated off the undisclosed route that cuts down through back ways and small streets, and they're sending that pay figure to them. So when you hear them say, we disclose 8% out of route miles, drivers wouldn't think, and this is what Garza 1 recognized. This is where they came up with and said, look, this is a good faith fair dealing claim. It's bad faith to say, I want you to drive this route, I'm mandating it, or I'm suggesting it as the only approved route I'm going to tell you about, and then I'm going to pay you on this route that I'm not disclosing, that's calculated over here, and then you're calling some of those miles out of route miles. So you're driving the route you're required to drive, but you're being paid for a route that you've never heard about, you don't know where it is, you can't alter your behavior and take that route. So when they say, well, look at what Garza did on the MS carriers. Look at MS carriers. MS carriers said, you're going to lose 6.5% because, one, we calculate city to city, city center to city center, which is the same as the city-state pairs. That's the opposite of what Swift said here, even though they do the same thing. They said it's zip code to zip code. And they said you'll lose miles if you drive outside what the guide prescribes. So what they did in MS carriers, not that it really matters here, but it highlights the differences in facts, is they said if you go outside of what the guide prescribes, they're telling them the HHG short route miles. They're telling them that.
The respondents make much of the fact that it's plain to the drivers that they are being paid, the software dictates that they're going to be paid less than for fewer miles than they actually have driven. So they argue from that that the plaintiffs know that. How does that knowledge bear on each of the two prongs of your breach of the duty of good faith and fair dealing?
Well, let me say two things on that. First, it doesn't affect the contract obligation. What your knowledge is on something doesn't affect what the language you agreed to was. And again, that's where your good faith, fair dealing restrictions come from. But I would say it doesn't mean anything either. Because when you say the HHG number is less than actual miles, of course it is. The point is it's going to take a route that is the shortest you can possibly do on the route you drive, and that's what you get paid.
So, but I think what the respondents say is that it may have been a breach, or may have been a breach of the duty of good faith, but you knew it. You continue to drive for us. Now, is that if the drivers knew that they were being shorted, if you will, or compelled to take a route and not paid for the full miles, how does that affect their claim for breach of the duty of good faith and fair dealing?
Okay, I understand that. And I'll say, first, I want to clear up one thing on when they say that the number's less. It's always going to be less because you don't pay for detours, you don't pay for on-ramp, off-ramps, you don't pay for missed turns, you don't pay for scaling stations.
Okay,
There's a
but
lot
your
of
claim
things.
is not that. Your claim is different than
We're
that.
not trying to get those miles paid for.
Right.
So your question really seems to me to be more, do they have a waiver claim? Because it's not going to adjust the contract claim. So you're saying that they, at some point, was there sufficient knowledge that the driver knowingly, voluntarily, and intentionally relinquished a known claim?
Well, I'm not sure it's waiver. I'm just asking you how that knowledge affects the elements of your claim. Is it part of your claim that the plaintiffs have to be ignorant of it? Or can one breach the duty of good faith and fair dealing by imposing on the other party, which the other party takes, because it's the only way to drive, it's the only way to work as a SWIFT driver, imposes a term that's contrary, as you say, to the benefits of the bargain?
Well, if it comes after the contract, I don't think it has any effect. If they had explained to the drivers on the front end, look, here's how the HHG works, these are its various options, these are the ones we're choosing, and we're not going to be paying you on the route you're driving, and we're not going to be accurately assessing it on the starting point and the ending point, clearly you would not have a problem here. We would not have a case. But that's not what they did. What they said was, look, we're going to pay you X cents per mile, and we're going to calculate mileage on the trips using the HHG. So could you come up with a scenario where a driver knew everything about the HHG, meaning all of its options, its ability to route through certain points or using different methods to route that are more accurate, some more accurate than others, and they knew how SWIFT used it, right? Because it doesn't do any good to just know how the HHG works. You'd have to know how they're using it, how they're implementing it. And then you'd have to know, because it varies. So some drivers, if you drove Phoenix to Los Angeles, it's a straight line. The HHG route is probably the same as the route that they're telling you to take. And so you have to know that on average, on the whole, the system is shorting you on the route that you're driving. You'd have to know all of those things. And I suppose at that point, I don't know, I would say it's more of a waiver argument again, but it doesn't affect the contract obligation is what it is. I don't think you get some sort of credit for having a super knowledgeable driver when he agreed to the same language as a non-knowledgeable driver. Because again, under the restatement, under Garza 1, under the whole point of good faith fair dealing limitations, it's supposed to similarly treat similarly situated people.
What about the second component of your claim, which I understand is that SWIFT did not fully explain to the drivers all of the implications of its choice of a particular sort of software? How does that not raise very plaintiff particularized defenses or proof?
Well, first, because again, those disclosures don't change the contract obligation.
Well, but if the claim is SWIFT failed to explain something, and SWIFT says we did explain it to him and him and him, how does that not undermine class certification?
Well, it could if the explanations were correct and robust and explained everything they're doing. But the only thing they have on disclosures are, hey, we're going to pay you 10% less because it's an air mile, nautical mile conversion, which is totally false. Hey, it's 6% and it's a chart using There's only about 5 things they've got. So the other one is a chart using Google Miles that has a straight line routing that says 6% variance. Well, HHG doesn't route straight line. It's not a function of household goods mileage tracking, and it's not Google Miles. So it also sort of conveys to the driver that it's immutable, that it's 6%, nothing can be done about it. What you have to explain is it's 6% only because of the way we're choosing to implement the HHG. They haven't done that. You'd have to explain how the HHG works and what its options are and what you're choosing to do with it. That's going to short the drivers and not pay them for what they expect. Because again, on the contract language, if it's per mile as calculated by HHG, a reasonable fact finder could say, hey, you should pay them for the route you told them to drive. That's a justifiable expectation. And we may not win on that, but you'd look at the language to come to that conclusion, and they would look at the same language to say, no, you can't come to that conclusion, or it's not a justified expectation. But you don't go into like these disclosures. But let's say you do. Let's say you say the disclosures all come in. We've got disclosures that are false, misleading, says they went zip code to zip code, which is more accurate, but they did not. And we have our disclosures, and their disclosures are all common. So they could put all their disclosures on and say this was our corporate effort to try to educate people on how the HHG works, and a jury will find out whether it was or wasn't enough.
But is that a class issue, or is that a class member per class member issue?
No, we're assuming that everything they did applies to the class as a whole.
Are you assuming one of the issues that they raise in their briefing is the fact that the merger of the two companies brought in drivers with decades of experience driving who knew HHG and who had been a part of this process? Are those people members of this class?
Yes, but they don't. The showing that they've had from an evidence standpoint is the only thing these drivers know. They know nothing about how HHG works. Here's what they know. The HHG is less than actual miles. And my response is, of course it is. It's only logical it will be, because it's the minimum distance between 2 points. That's the only thing people in this class, and frankly in this company, know about HHG. They don't.
So they came into this combined company with years of experience, knowledge of how it worked, and knowledge that it would result in them getting credit for less miles than driven. Is that correct?
They knew that
But my point being,
yeah.
Earlier you were talking about what was pre-contract versus post-contract, basically in regard to what they were told. These people had decades of knowledge of this. They'd use this in their job for any number of different years. They're members of the class as well who are similarly situated?
Yeah, but they're not. What your fact pattern is not accurate on the evidence in this case. What we're distinguishing here between is a guy who knows that the in-route miles, if you will, the miles for the route that he's been told to drive or suggested he drive, those are being shorted. You wouldn't know if Mr. Garza says, I'm getting 10% less on my miles, you don't know if that's because he's driving out-of-route miles, if he's driving personal driving, unauthorized driving, or whether those are the miles that we're not asking to be paid for here. But there's no showing here that anyone understood that if you say drive this route, and again, Mr. Garza's specific example was they sent him the route from the program, the short route from the program. And the route could also have been one where you crafted it through the route you told him to drive. But they sent the short route, and they said, if you drive more than that, if you drive over that, you're going to end up with unpaid miles.
But didn't he know by looking at the odometer every time he took a trip that he drove more than he was paid for?
Right, that's why he sued. He understood he drove more, but he doesn't know why it's coming in at 10 to 15% more. He doesn't understand why. And so
does it matter why? I mean, he knows he didn't make any wrong turns. He knows he didn't do any personal driving.
Well, yeah, sure it matters, because it matters that you know that Swift is making determinations in the corporate headquarters of how to implement the HHG program. They've made the decisions on how this works. So they've decided we're going to send the drivers with this undisclosed mileage information, tell them to drive this other route, and the two are totally different, and we're not going to pay them for those miles.
You on the issue of disclosure, you referred to corporate disclosures, official disclosures that are made, 5 of them, I think you said. So are the plaintiffs willing to accept, for purposes of this lawsuit, that everyone in the class was informed of these corporate disclosures?
Yes.
Okay.
And I'm getting down to 3 minutes, which I would like to reserve if I could, or,
Well, you can reserve that, but
Okay.
you haven't got to damages yet.
okay.
Could you tell us how?
Yes. Sure. First of all, again, this never was raised in any of the motions to certify or to decertify, and so the record, again, doesn't have much of this in there. But there are two components to our damages theory. The short route versus the required route. That's one component. The other is just dialing in with the option that allows you to more specifically or precisely figure out the starting and ending point. If you add both of those together, that's the universe of the damage that the plaintiffs seek.
I don't think we know about the second one.
Well, that goes to when you go to the pickup point. It's the city-state pair. I don't know if that's clear in the briefs, but so in Phoenix, the city of Phoenix is like this, and it might be 35 zip codes, but it's one city, and there's one point they use, and that routes. And that's less accurate than if you go to each zip code or to smaller, like an intersection or what's called an SPLC. You can pick other ways to do it that are more accurate.
How
And
does that
so,
affect your? I think we understood that the damages are the number of miles that each driver drove but wasn't paid for. Is that different? How does that?
the number of miles the HHG would have calculated had the route been done as accurately as the HHG would permit it.
Okay.
It's not actual. We're not seeking actual miles. We're seeking to go put it on the route it's supposed to be on, and then dial it in where they have more accurate options. And just clarifying one thing in the questions, you say the least favorable option. That's not a damage theory. That's just a fact that came out of discovery. Our claim is they have to use the most accurate theory. If they used the second most accurate theory, it would still be a claim because the goal is to pay the drivers for their miles.
And
Now-
are those damages the same under both of your prongs? The choice of the particular variety of
Yes.
software and the failure to disclose it?
Yes, because if you make these two changes to the software, it will approximate actual miles on the required route. It will approximate actual damages. There will be no variation. And if it is, it's because the driver's driving something. And so our damage model, if you want to call it that, is add up what the miles are for the required route, add the miles in that would be gained by being more accurate, subtract the miles they already paid, and multiply that by the applicable contract rate for every driver for every mile they drove. Because we have now, part of the reason this is in a little bit of an unsettled state is at the last minute, Swift, 6 months before trial, after denying for 10 years that they had calculated any or collected any mileage data, said, oh no, we actually do it two different ways. We do it in fuel miles and we do it in this electronic control module. They gave us that a couple months before trial. It wasn't complete. They had to make 6 supplemental productions, and at the time the decertification was granted, we still didn't have a complete set of data.
So that's why it wasn't in your damage disclosure.
That's why it wasn't in our... No, we did disclose. We did an expert report on the miles, but he had to do some assumptions. It would be fixed if we had time. They would have given us the data. Our guy would have fixed it. He could have done some alternative evaluations or analyses. And then we took that report and gave it to a finance guy, and we issued and served reports doing both miles and the dollars. But what we couldn't do is go in and have them, say, for example, break out the difference between the two components of our damage. But I think we have two ways to prove damage. We have the way, if you had done it correctly and used the HHG the way we're saying it should be done under the contract, the most accurate way to do it, that's one method. You'd add up what it would have done. And the second is just expectancy damages. You've created this situation where you're putting out a route saying, drive this route. We drove this route. You didn't tell us how this worked at all. None of your people seem to know how it worked. And you're putting out these things on air miles and straight lines on Google Map, but you're not telling us, look, here's what we do.
But how is that claim affected by what Swift said to the drivers or what the drivers knew? In other words, is it sufficient to prove a breach that the drivers weren't being paid for a significant number of miles because of the software that Swift chose? Or is that claim defeated? That simple, you didn't pay me what I drove, is that simple claim defeated by the fact that the plaintiffs knew every day that they weren't being paid what they drove?
Well, I don't think it's defeated, no, because the contract says you will be paid
Okay.
per mile as calculated by the HHG. And so you either get what the HHG says, using it correctly to do it, because per mile is inconsistent with changing what a mile means. The goal, I think it's a reasonable interpretation to say the goal is to pay the guy for the miles he's putting his truck on the road for your benefit as instructed. I'm not saying pay him for when he drives off on a lark, but when he drives for you, the goal at X cents per mile, where they're taking into account his time, and in the case of O&Os, the rubber, the gas, whatever, that the goal is to pay him for that. And if they're going to go and manipulate the system and make it do less than that, I think you always have that contract claim. If you have a bunch of knowledge about certain things, I don't think it changes that. But I don't think it ever affects the adoption, if you want to call it that, or the use of the HHG, because that is totally Swift-centric. Okay. If you adopted a bad program, then you're kind of stuck with that.
Just one real quick. Yeah. But counsel, what that takes us back to is the direct language of the contract that you're seeking to have enforced.
Yes.
But you're calling it an equity claim for breach of the implied covenant of good faith and fair dealing.
I don't think it's an equitable claim. It's a legal claim.
Breach, okay, let's just call it breach of good faith and fair dealing.
Okay.
All right. So even though the contract has been tossed, you're going back to the contract to enforce a contract provision under good faith and fair dealing.
Well, the contract hasn't been tossed.
Summary judgment on the issue of contract, right?
It was tossed on the issue of whether or not he has a right to, whether or not he can say you don't have a right, you're not allowed to use the HHG. They obviously have to figure out how they're going to pay him on a per mile basis. So what the court threw out was, Mr. Garza said, look, you can't even use the HHG on me. You don't have a right. It's actual miles driven. He threw that out. And the reason he threw it out, but let's be clear, he didn't throw it out on the merits. I don't believe. Well, for the employee drivers, he didn't throw it out on the merits. What he threw out was, they went up on appeal, it's vacated and they come back, he reverses his certification order, but then he took away the tolling. He deprived them of tolling. So people who had been in their class for 5 years suddenly are no longer, because of Arizona's 1-year statute of limitations on employment claims, they're suddenly out in the street and that claim's not viable. And that will have to be appealed directly at the end of the case. But it's not on the employee side. They didn't lose a claim that it's improper to use the HHG. They lost a claim that their claims weren't timely because of the gap between going up on appeal and coming back and having the court go, ooh, I got to change this, and then he certified the case, and then he wouldn't give them credit as you would if you went up on appeal again. After you came back, you went up on appeal, the court rubber stamped the same opinion and sent it back, all of those people would have been timely. Because when you go up on appeal, you come back, it relates back to the date of denial of certification. But the court said, nope, I'm not doing it that way, and all those people are out. So that claim is still behind us, but it wasn't thrown out because of the language of the contract.
Thank you.
Thank you.
Okay, would you add 5 minutes back on to both sides, please?
May it please the court.
Why don't you wait a second? We'll get the timing straight. Thank you.
Oh.
Thank you.
May it please the court. The court has identified precisely what the issues are in this appeal.
Your name?
Oh, I'm sorry. My name is Jim Sullivan. I apologize, Your Honor. I'm Jim Sullivan on behalf of Swift Transportation. The court has identified precisely what the issues are. They are complicated, and I appreciate the court giving us additional time to talk about them. Initially, the court identified what the claims are in this case, which is some sort of breach of the duty of good faith and fair dealing in adopting or selecting the HHG, and also a breach of the duty of good faith in failing to explain how the HHG worked. When you look at a class action, I believe the court has to look at how the case can be proven with common contentions throughout, so that the claim of Mr. Garza, who is the sole class representative, that is the only truck driver that plaintiff has identified to testify at this case. So Mr. Garza's claim has to be able to carry the day by proving a liability theory under the breach of duty of good faith and fair dealing that's recognized by the Arizona courts. He has to prove damages But in between there, his damages have to be causally connected to what his factual contention is and what he alleges his damages are.
As do how many people in the class?
80,000 people.
Okay, so there are another 79,999 people who have to be in the exact same position as Mr. Garza.
And it's exact is probably a little bit too precise. It has to be capable of proving the claim with a common contention, a group of core facts that can carry the day so that when Mr. Garza proves his case, it's not necessary for the court to try the other 79,000 plus claims, because if you've tried one, you've tried them all. That's the concept of the class action, is to not to burden the court with continually trying the same claims over if liability is proven by proving the case of one person. And so Mr. Garza's claim has to be able to carry the day for everyone. So here we're talking about the breach of the duty of good faith and fair dealing. The first question is, can he prove liability? His theories are, as previously stated, that Swift adopted the HHG in bad faith and that Swift didn't explain it. Well, the duty of good faith and fair dealing is very precisely described in Arizona cases and in the restatement. The concepts of it are uniformly accepted. The breach of the duty of good faith and fair dealing has nothing whatsoever to do with pre-contractual negotiations and disclosures. It is contract hornbook law that the only thing the duty of good faith and fair dealing has to do with is the performance of the contract as it is written and the enforcement of it. That's the only thing it has. So whatever, you can't make a duty of good faith and fair dealing claim saying that you misled me into me entering into this contract, or what you said to me before we entered into the contract was untrue. There's many, many cases on that issue, and I don't think plaintiff would dispute that. So first of all, their claim is not even a claim under the duty of good faith and fair dealing. I will tell you, we've argued that vigorously to the court, and he's continued to let that case proceed because of what I think is perhaps an erroneous comment, I think, by the Court of Appeals in the vacated Garza 1 case, where they talked about this duty to explain. There is no duty to explain under the duty of good faith and fair dealing. That connotes some sort of pre-contractual obligation, and that's not what this case is. If you're talking about pre-contractual discussions, that's a misrepresentation case, negligent misrepresentation, fraudulent inducement, that kind of thing. They didn't bring that claim because they know that you can't get a misrepresentation class certified because reliance is a fundamental principle of misrepresentation, and the case law is uniform that you can't prove reliance on a class-wide basis. So they've tried to morph this misrepresentation case into a breach of contract case.
But the first of the two claims, though, I don't understand to resemble a misrepresentation claim.
Okay, so let's
What I
talk about
understand
that.
is
So
implied in the employer-employee or contract relationship is a duty to pay someone fairly. That's how I understand this. And as I understand it, the variety of HHG, HGH, that's the other thing.
Sorry, the acronyms
that Swift chose doesn't do that. And so regardless of whether the drivers knew it or not, they were being shorted every day. And that's, as I understand, is the first claim.
Okay, let's talk about the first claim. So we came into the motion to decertify the recent one with only the duty of good faith and fair dealing claim. The case was actually certified under both breach of contract and the duty of good faith and fair dealing. So we filed a motion, Swift filed a motion for summary judgment on Garza's breach of contract claim on behalf of himself and the members of the class that he represented. Garza's contract with Swift specifically provided that he would be paid by his dispatched miles. Remember, Garza's an owner-operator truck driver. Owner-operators are independent contractors that own or have their own truck. and they've signed a lease contract to lease on to the trucking company, and then they get loads from the trucking company and they get paid, but they have to pay their own expenses and that kind of thing. It's a fairly detailed contract, and we've provided the court with numerous examples of those in the record. Mr. Garza, having come from MS Carriers, had a unique contract because his contract said that his mileage would be based upon his dispatched miles.
How unique?
Pardon me?
How unique? Utterly unique?
Okay.
Or is there a
It's
very
u-
small portion of the certified class that has that contract?
And the difference is because his contract was with people that came in from MS Carriers, the people that were owner-operators with for Swift before Mr. Garza, and the people that weren't part of the MS Carriers deal, and then everybody that signed the contract for Swift the next year, all signed a contract that had a variation of you would be paid by the dispatched miles as determined by the Household Movers Guide. So on March 6, 2012, and it's the appendix, starts at page 369, Judge Gamma explained why he granted summary judgment in favor of Swift. The first thing he said was that with respect to the variations of the contract that mention the Household Movers Guide, that interpretation is not susceptible to the interpretation that plaintiff makes in this case. That is, they should be paid their actual miles. He says specifically, as to the contract containing the Household Movers Guide dispatched mile or household goods dispatch miles compensation provision, the court agrees with Swift that the plain meaning of these words simply is not reasonably susceptible to the claim advanced by plaintiff, i.e. actual miles.
What's the date of that order?
Pardon me?
What's the date of that order?
March 6, 2012, and it's page 369 in the appendix. He went on to say, Mr. Garza's contract was a little different because it only said dispatched miles, and here's what the court said as to that. The court finds that the reasonable interpretation of dispatched miles means the mileage stated in the pre-planned message given to the owner-operator driver offered the trip. To what extent dispatched mile relates to, quote, actual miles is irrelevant. The driver can agree to or reject the offer. It is common knowledge in the trucking industry that the HMG is used to calculate dispatched miles. So the court dismissed all breach of contract claims brought by Mr. Garza on behalf of the class.
So
Now-
to assert that there's a claim that continues based in breach of contract, your position is?
So now what they're trying to do is take the duty of good faith and fair dealing and say we still have a claim for something else. But what the plaintiff is ignoring is that another part of the Hornbook law of the duty of good faith and fair dealing is you can't use the duty of good faith and fair dealing to change a term that's already in the contract. Judge Gamma has already ruled that the contract means Household Movers Guide and it doesn't mean actual miles. But they're trying to bring that in through the back door by using the duty of good faith and fair dealing. We cited to you the bike fashion case, and I think if you look at footnote 2 in our brief, we talk about this whole issue, and I think we mentioned it earlier in the brief, that this claim is not cognizable under Arizona law or any other law in the country that I know of.
Which claim? Define the claim.
The duty of good faith and fair dealing claim that says we should be paid actual miles.
I don't think they're saying we should be paid actual miles. I think what they're saying is we should be paid the miles that you told us to go. And which I guess as what Mr. Carey said was they would say, we want you to drive from here, from A to B to B to C to C to D. But in reality, they were calculating the miles from A to X to Y to Z to get to D. Okay. And that was different. And so I guess I'm confused because I don't really think that they're They were just asking for the miles that they were told to drive, not the miles that was calculated by, not the dispatched miles as determined by the HHG.
Okay. There's two parts to the answer to that question. First of all, the duty of good faith and fair dealing is based upon what are the parties' reasonable expectations. Okay, so did the plaintiffs have a reasonable expectation that they would be paid something other than the household movers guide? The plaintiff is trying to present this household movers guide as some sort of scheme or mystery. This is the household movers guide book. It looks like a big Rand McNally map. And if you look at it, it's got all the cities and states in it, and it tells you the miles between each little prong, just like if you were to buy a Rand McNally map over the counter, how each little segment between each city is this many miles. The miles are a little bit different, and this book's a little bit different than what you would buy at a convenience store, but this is the last version that was put in paper. I think this was the 2004 version, which is 17, but it's still the same principle. And the concept that the household movers guide is a mystery and that the plaintiffs didn't know what it was simply doesn't hold water for several reasons. First of all, the household movers guide is something that Judge Gamma has already ruled is common industry knowledge. It's used. Swift's contracts with its customers require that it charge them based upon the household movers guide. Swift isn't having a scheme where they're able to get more money from their customers, charging them more miles than what they're paying their drivers. The miles are exactly the same. There has to be a standard, Judge. That's why they do this. And so what the household...
I think we acknowledge your proof about, and Judge Gamma's findings, that the drivers knew something of this. They knew at least they were getting paid for fewer miles than they drove. I think what Judge Orozco's asking is, isn't there a possible breach of the duty of good faith and fair dealing if Swift requires a driver to drive A, B, C and pays the driver only for driving A, D, C?
Not if the driver knows it, though.
Why is that so?
Well,
what element does that disprove?
well, all right, so I mentioned in Judge Gamma's order where he talked about this pre-plan. And basically what a pre-plan is that before you actually get dispatched, you get a Qualcomm message. It's similar to an email message. It tells you where you're driving, what your origin is, and what your destination is. It tells you the miles that you're going to be paid. Those are the HHG Household Movers Guide miles. They come directly, in terms of the way the system works, they come directly from the customer order. The customer order goes into the dispatch, which is the miles. The driver also gets paid his empty miles. So you have this loaded miles and empty miles. The driver knows how many miles he's going to be paid for that trip before he ever gets dispatched.
I suppose viewed in that way, every trip is an offer and acceptance.
Well, that's what Judge Gamma...
The offer is made, you want this trip, and the employee or the driver takes the deal or doesn't.
In one respect, that's true. The other issue is that what impact does that have on their reasonable expectation? When they get sent, and you have to dig through the records, but when they get sent the route, first of all, Mr. Garza doesn't have the claim that plaintiff contends. Mr. Garza was an owner-operator. He wasn't required to take any route. He's an independent contractor. He can do whatever he wants to. He can go from here to Kingman and decide to go to Denver to visit Grandma on the way if he's got enough time. He's not going to get paid for that. But he can take whatever route he pleases. He was not an employee driver. So I don't think there's any dispute. There's no contention in this case that the owner-operator drivers, what Mr. Garza was, were required to take any route. They had a suggested route, and the suggested route took into account a lot of things. And Swift has a lot of programs that help drivers figure out what the suggested route is based upon fuel stops, where the fuel might be more cheap or cheaper, where Swift might have a particular deal with a fuel provider. Fuel's a big issue in the trucking industry. You got a 500-gallon tank. You can imagine it's very expensive to fill up, and if you can save 5-10 cents a gallon, it's a big deal. So those all go into what Swift suggests to owner-operators as to the route to take.
Was the Qualcomm, here's your route, here's your miles that you'll be paid for, has that been in place since the beginning of the time period that's relevant
The
here?
Qualcomm dates back to the early 1990s. And if you want to see a picture of what a Qualcomm looks like, in the exhibits, we provided you a copy of Swift's driver manual. And if you look in the record at page 981, there's a document there, and it looks like it's in a box, and you'll see it. It looks like an email, and it's called a pre-plan load information. And you'll see about 2/3 of the way down there, it says miles loaded 507, empty 83. And then the next box says accept pre-plan, and it says driver is committed to pre-plan, and then it says wire in. Driver can say wire in, yes or no. Not going to take that trip. So that's what Judge Gamma was talking about when he said, in essence, kind of what you said, Judge, is that this is kind of a mini offer and acceptance. That was as to the breach of contract claim, but it's no different for their reasonable expectations. I mean, their reasonable expectation can't be anything other than I'm going to be paid the miles they tell me before I even leave. The other thing is that, as I said, this mileage system is not a mystery. It's commonly available out there, and the drivers know why it is different and why and what the mileage differential is. And this comes to the questions that you've asked about the damage theory. Plaintiffs, I'm not sure I followed everything that was said, but plaintiff has consistently maintained that the damage theory in this case is the difference between the miles they were paid and the miles they actually drove. There's been no other theory, and I'd suggest that if there is some dispute about that, we did have an argument about that before Judge Gamma, and if you look in the appendix at page 2995, we go through there in some detail as to what the disclosure has been here. I think for brevity's sake, what I'll say here is that plaintiff's expert who did the damage calculation said this as to how he calculated damages. Plaintiff claims that using the HHG dispatch miles results in drivers being paid for substantially fewer miles than actually driven. That's what he did. He calculated he tried to anyway, calculate the difference between the miles that were in the pre-plan. That's what we gave them, because we gave them all of their pay records. They knew all the miles that these people were paid for. He has that. That's the same information that was in the pre-plan that each one of these drivers hit Y for and accepted, and now they're trying to change it to get paid actual miles. And I suggest to the court that that's, again, an end run around the breach of contract claim. You can't use the duty of good faith and fair dealing claim to change an express term of a contract. Judge Gamma's already said you can't get paid actual miles. That's what their damage theory is. So they're trying to bring an actual mile case when that case has already been dismissed. So affirmative defenses. The three affirmative defenses that we've suggested, there are several asserted, but in the decertification we talked about the statute of limitations, waiver and estoppel, and latches. statute of limitations is a good one to start with. The employee class starts on, I believe, April 9th, 2009, and to the present. So with respect to employees, the Arizona statute of limitations is 1 year. If there is a driver who started driving for Swift, an employee driver, let's say they started driving for Swift on January 1, 2007. Say they're this category of people that was in the dark. They didn't know what the Household Movers Guide was. They didn't know it was less. But by the end of 2007, they knew it. They knew that it was less. They knew about the pre-plan. They knew that when they looked at their odometer, looking at, 7-8% less, their cause of action accrued then, because that's the discovery rule. You know you have a cause of action when you have a reasonable belief that you're not being given what you're promised. The statute of limitations starts then, and it would have run by the end of 2008. If that person's still driving for us today, they're part of the class.
But you can work an algorithm that would handle that issue.
I can't imagine how, because it's based upon what that person knew. I have to depose him to find out what did you figure out and what did you know.
No, your theory is he knows, with every trip, he knows what he's being paid for, and by looking at the odometer, he can tell how many miles he's driven.
Then that follows to the next one, the issue of waiver and estoppel. If plaintiff is willing to accept that, and we agree to an algorithm to exclude people out of the class because once they knew, then they should have done something, what about the people that knew, figured it out quickly after a month? They look at a month, they get paid every week. After a month, they're saying, here's my odometer, here's my pay, it's off. And they didn't do anything to assert their rights. They continued to take loads for Swift. They accepted it. They never objected. They've waived their claim. So those two issues go hand in hand. You can't have it both ways. You can't say, well, I can figure out who to get out of the class because I'm just going to assume that everybody figured it out by a certain time, and if their statute ran, then they're out. Well, we have to do that for the waiver and estoppel issue, too, as well as the latches issue.
Well, but aren't you trying to have it both ways, too? I mean, you say every trip is a contract. So every time they accept it, then why isn't that a new claim?
Your Honor, I don't know that I'm trying to have it both ways. I think what I'm suggesting is that there's no way, with all of these issues, that Mr. Garza, who drove for Swift for 3 months, but had been a driver for 6 years prior to that and had been paid according to the HHG, how in the world can Mr. Garza prove that claim on behalf of 79,999 plus people with all of these issues? Mr. Garza had a written contract. He had a contract that the courts already determined that Swift complied with and granted summary judgments against him and every other owner-operator. It's not a matter of me trying. Part of what the plaintiff has argued is that Judge Gamma got too much into the merits and that I'm arguing the merits of the case. The point when you're looking at a class certification is you don't decide the merits, but you have to look at what the factual issues are going to be with regard to the class to determine whether there's a common set of proof that can prove the claim on behalf of everybody in one fell swoop, as said in the Walmart versus Dukes case. It's a matter of due process. Because Mr. Garza gets up there and says this is what his claim is, but I have all these other issues to drivers who will never see the light of day in this courtroom, and I have affirmative defenses. Effectively, I won't be able to cross-examine Mr. Garza about it. Effectively, we'll be precluded from asserting our affirmative defenses and asserting the defenses that other people knew what he claims he didn't.
The broadest, most elegant way that I hear you advocating that by which we should dispose of the special action is to go back to Judge Gamma's rulings on the contract claim or the contract issues, and take from there that it's already been decided that the contract, the benefits of the contract could not include being paid anything more for any more miles than what the Qualcomm printout, readout says that you're going to be paid for. Because that's the sum and substance of the contract that each of the plaintiffs had with SWIFT. A breach of the duty of good faith and fair dealing can only lie for deprivation of the benefits of bargain, something that will preclude you from receiving the benefits. And so what I hear you saying is that the sum and substance of the contract has already been defined.
I think that's mostly true, but if I could just make
Okay.
sure, when you look at the Arizona cases and you look at what we've presented on the issue of the duty of good faith and fair dealing, the duty of good faith and fair dealing is typically recognized when the contract provides the party some sort of discretion as to when to declare a default or something like that, or if a party takes an express term of a contract and misuses it to some degree. SWIFT didn't have any discretion. The documents, and it's not a matter of me saying that we win liability. It's a question, can they prove it on a class-wide basis?
Well,
There's
that's
more
where
than sufficient evidence out there that the plaintiffs in this case agreed that they would be paid according to the Household Movers Guide. There's no discretion. It's for, I tried to come up with an example to present to you today, and the best one I could come up with was that if I enter into a note with my colleague and it says I'm going to charge you prime plus 1%, but he doesn't know what prime is. Prime's very low right now. What if in a year from now it goes up to 9%? He says, you didn't explain it to me. I didn't know prime could go up 8 points in a year. That's not a breach of the duty of good faith and fair dealing. I didn't have the discretion in the contract to say, well, I'll cut you a deal. The contract says what it says.
But if we rule on that basis, aren't we venturing into the merits?
No, you're suggesting that there's not a set of core common facts that can prove the claim that SWIFT did not act in good faith in enforcing or in performing under the contract. And it comes to this, the other added part to your question is, it's not just a matter of looking at Judge Gamma's order, because this concept of reasonable expectations comes in. And we've referenced this case several times, and there's a lot of the cases out there that talk about the propriety of having a class action for the duty of good faith and fair dealing. And I'd reference you to the case called Stratton versus American Medical Security. It's 266 FRD 340. This is an Arizona district court case, and there was a breach of the duty of good faith and fair dealing claim in that case, and the court said, because each class member's reasonable expectations require consideration, individual issues outweigh any common ones so that the court cannot certify a class. That is precisely what we're talking about here.
Okay.
That it's both. They can't try to contradict what Judge Gamma has already done, but they also have got to be able to prove these reasonable expectations on a class-wide basis.
Any further questions?
No.
Thank you. Thanks for your
Thank
time.
you.
Mr. Carey.
Thank you, Your Honor. First, when the court said, isn't that venturing into the merits, that's absolutely what it is, because we have an expert report that shows just on picking the location for drop-offs and pickups, there's 5 different methods to do it. There's SPLC, which are little points throughout the country that you can go to, intersections, latitude, longitude, the city-state pair. There's 5 ways they can do that. The other thing is, the book he's talking about does 2 things. The program does 2 things. It's a routing application and it's a mileage calculator. It'll do both. So when he says, he makes it sound like HHG is just this one, you put in your stuff and one number comes out. Well, it does the way they do it, because they only do it city-state pair and a number comes out.
Well, what about his point that before a driver starts out, before he accepts the trip, he knows what he's going to be paid for?
Well, sure, but he has a contract that told him exactly how they're going to do it, and this is the point of a good faith, fair dealing thing. It does vest discretion with Swift. It says you can use the HHG to figure out my miles, and it can be a reasonable expectation to say, I'm going to go on this trip, and you're going to apply HHG to that trip, which can be done under it, under the mileage calculation part, and you're going to tell me that number. So you enter into a contract, and you go out and you get a trip plan, and it says, I'm giving you 700 miles to drive from Denver to Phoenix, and it's 750 miles. Swift has exercised its discretion to decide not to apply it to the route you're going to be driving and to pick the worst case scenario, not the most accurate one on a per mile contract. Again, it's a per mile contract. That's the very exercise of discretion. That's what you're leaving to them to do right. And if it strays from the expectations of the parties based on the contract language, it's a violation of the good faith, fair dealing covenant. And so to clear...
You have a reference to where in the record is the contract that we're talking about, the written contract?
Well, the written contracts all are at the front of the decert motion. I think Mr. Sullivan laid them out. They vary, but they don't vary in this regard. And this is why it's one stroke, if you want to call it that. They all had the HHG applied to them the same way. There was no... Look, the judge considered whether you could go from dispatch miles to actual miles and rejected that. That doesn't mean that the way that you are under the contract going to calculate miles can be done arbitrarily. And to Judge Orozco, on your point where you're saying, they're trying to go to another route and get actual miles, that's not what we're doing. We're trying to say apply the HHG to that route and do it in the most accurate possible way. That's our fundamental damage argument. We go to actuals because if you do the two things we're talking about on the program, it approximates actual miles. Now, could we go in and have our expert put out an alternative calculation? And we were going to? Absolutely. But we didn't have their data. We still don't have their data. They withheld it for 10 years saying in discovery, in depositions, in discovery responses saying we don't keep miles. But yet they dropped terabytes on us of every driver, every trip, all their miles. We can calculate everything now. But we're not trying to get anything more than what we would have gotten had the program been applied fairly. And just on the knowledge of the drivers, again, you can look at the record at 2911 as the start of the PowerPoint I used at the trial court. There's nobody that knows how this works. None of their people work. None of their employees, the people that train recruiters, that run the payroll system, none of them knew how this worked. Not a single one. They had class-wide discovery. They had class discovery before they had discovery on the merits. They didn't find one person, not one that could come in and go, I understand Swift had other ways it could have done this. I understand Swift exercised discretion to come up with the smallest possible number and apply it to a different route. Not a single person. Not a single person. So are there people that know I'm driving and I'm short? Yeah, they're the same people that have a contract right to get paid a certain number of cents per mile. They clearly don't know enough to know why they're getting screwed or how much better it would be if Swift followed the justified expectations of the party and picked the most accurate mileage and applied it to the route you're telling them to drive. And I don't think it changes because the route is not required. They suggest the route to the driver. It's the only one they suggest. And the driver follows it. He has an expectation that the miles you're giving to him at that very same time apply to that route. They could have very easily said, look, we're giving you the shortest route. We're giving you the very shortest route under any legal road. And you're not going to get paid. So when you drive this other route, you're not going to get paid all those miles. But they didn't do that ever. The closest they did in 2012 after this lawsuit's been filed is they say HHG miles don't equate with actual miles. And again, of course not. Everybody knows that. There will be miles you drive that aren't the shortest amount for the road we're talking about. There will be miles you weave off to go get gas or take a bathroom break or take a detour. They're going to be different. And there is zero evidence. And again, this is their responsibility. If they're going to come in and say affirmative defenses of waiver and all this other stuff, they have to have evidence. If you look at their motion, they're all hypothetical. What if somebody knew this? What if somebody waived that? There's not one person they've identified, not one of these 80,000 people, all of whom had the HHG applied to them exactly as I'm describing, that they came forward and said, I understand how this works, and I just willingly went along, and now I'm going to give up my claim under the contract. I want to relinquish it. Not a soul. So if you say through all this discovery that we got an issue, it's not based on the record in this case. because there's not a single person. Their own employees didn't even understand or care how this worked. And so when we're looking at what we're trying to do here, it's very clear from the contract that it's a possible outcome from a jury, that a jury could say, hey, look, it's cents per mile. Of course you're trying to calculate this correctly. Let's do the best we can, and if it strays from that, then you violated the covenant of good faith and fair dealing. It's not about trying to go to actual miles. That's for a later day. That's for a different appeal. Thank you.
All right, thank you. Thanks a lot. Thank you to both sets of lawyers for coming in. Appreciate your attention to the issues. One small point, and we really appreciate your e-filing at Turbo Court, the exhibits, they were great. And I can't remember which side did it, so you can't take offense. We're not going to hold it. It would be very helpful to give us someplace where each of the appendices is broken down by pages. We were cited to page 1238, but we didn't have a clue where in the 34 appendices we could find page 1238. So we had to kind of sift through each of the appendix. It's like opening a book. Oh, no, 25. So if you could give us a table.
Can I just
maybe we just missed that.
And we'll send you a letter that describes because I have them.
Do you? That'd be helpful. Or some.
If I understand you, the question is, what volume of the appendix is a page number?
Exactly,
I
because
think
they were
ours
filed
did that,
separately.
So it's theirs.
Okay, because they were filed separately, so they're separate documents in our case management system, and we had to open up each one to find particular pages, But
Okay.
it's not a huge deal, more to the future than the past. But we really appreciate your comprehensive filings, by the way. They were very helpful. Thank you. We'll issue a decision in due course, and we stand adjourned.